With Edward Snowden, obviously we're talking about a client who is of tremendous interest to intelligence agencies around the world, not just the United States. There probably are not a set of precautions that can be taken that are strong enough to guarantee confidential communication between us. On the other hand, many lawyers will have the experience where their clients are actually the experts on a subject. In this case, Edward Snowden is one of the world's leading security technologists. He certainly knows much more than I do about encryption and about the ways in which governments attack it. So in one sense, this is almost impossible. In another sense, from an ethical point of view, it's very easy. It's impossible to be sure that an adversary like NSA with an $80 billion a year budget and many other spy agencies around the world have not found a way into our communications. But all I can do is follow his guidance about the safest and most secure way for us to communicate. Now, we've spoken publicly about this, so I won't be revealing that we use a program called Tails that allows us to chat over encrypted channels. We have to be online at the same time in order to do that. It's not the most efficient way to communicate. Surveillance does, in effect, put a tax on lawyers' time and resources in order to do this. And there will always have to be topics that we can't discuss, even in those most protected channels. Some that we discuss only face-to-face, and then there are other topics that we won't discuss face-to-face because of the surveillance environment that might exist there. So the short answer is this is one of those instances where the most ethical thing to do as a lawyer is exactly what the client tells me to do. And I would say the rest of my communications don't fall into an easy pattern. We have slowly but surely begun to install PGP encryption on all of the ACLU's computers to at least have that available as an option. But I would say that about 25% of the emails that I send and receive during a day use PGP. And the rest of the hundreds of emails that make up a lawyer's day, where in the past we might have picked up the phone and made a quick phone call, but now we just use email. We don't encrypt and decrypt each one of those because of the very long passwords that are involved. It just would be too cumbersome and too much of a burden. And finally, I will say this, that I work for an organization called the ACLU. It has existed in the United States for almost 100 years. It is perhaps the most influential NGO of its kind in the United States. It would be extremely risky for the government to target the communications of ACLU lawyers. It would have to be a very compartmentalized program where only a very small number of people knew about it, because if that kind of thing reached the press, it would be a devastating story for the government and would do as much to erode its credibility as all of the Snowden stories that we've seen to date. So I don't believe that the government would undertake that kind of legal and political risk. That doesn't mean that they aren't getting these communications through targeting of our clients, and we'll get to that in a moment. But I don't believe that practicing the kind of law that I do in the United States is equivalent to practicing it in a place like Russia or a place like China.
Mm-hmm. And you've touched on this briefly, but since taking on the Edward Snowden case, has this really changed any of your personal and professional habits?
Well, I can't imagine that the answer is no. I am aware much more often of all the ways in which we're tracked. But I think many people have experienced that awareness since reading the Snowden disclosures. They realize that that smartphone in their pocket is a little police officer that they carry around, and that the search terms that they enter somewhere might be getting stored in some database. I think we all now have this feeling that there are huge data centers that are recording all of this. There might not be an individual reading it today, but someone might come under suspicion tomorrow, and all of this could be sitting in front of an agent. So I think we all have that kind of awareness. But I don't look over my shoulder, if that's the question. I don't fear for safety. I've never been harassed at an international border, questioned by anybody. I feel like I have a lot of room to do the work that I'm doing. I'm not sure. I think, as I said before, I think this is an exceptional case where, in general, all the risk belongs to the client. But in this case, the risk and the expertise both belong to the client. So no, I think that confidentiality is something that we've always taken extremely seriously. It's about as close to sacred as an obligation that a lawyer can have. So I don't know that it has, changed my view so much about it, but I certainly think about it a lot. No one evades mass surveillance. Let's be clear about that. By its nature, mass surveillance is passive. It's not targeted. It sweeps up indiscriminately huge troves of information. If the British government is, through its Tempora program, is sitting on the backbone of the internet, no one is evading it if our communications are going through those channels. Now you can do a better or worse job in protecting the content of your communications depending on what tools you use, but no, we are all swept up somehow. And even if it's not an NSA program, when I drive my car, small cameras that are placed in lots of places are snapping pictures of license plates as they go through with GPS coordinates. That information is being fed into databases that are joined into regional databases. And so now someone in the United States can know where I was by knowing where my license plate was. So many other databases like that are just being created, not by spy agencies making a decision, but by how cheap and pervasive data collection and storage has become. So evading mass surveillance, under those terms is really not an individual possibility or responsibility. What we need to do as a society is make mass surveillance more expensive, more difficult, more cumbersome, to create the incentive for the government to do targeted surveillance rather than mass surveillance. Well, I think all lawyers should be thinking about who their clients are. Do their clients have intellectual property that might be valuable to a foreign government or to a criminal hacker? Do their clients have confidential information that, if disclosed, would be ruinous or embarrassing? You could go down a list of categories like that, and I think that almost all of us have clients who have information that would be of serious interest to someone else. And if that's the case, lawyers need to wake up to this new threat model that we've seen. Today it's the NSA, but the NSA should not be the only entity that we have in mind, because these tools are proliferating, they're getting cheaper, they're getting more widespread, and so virtually every government will have the capabilities that the NSA has shown, and not just governments. We're going to see criminal hackers who are starting to use the same kinds of tools. And so, yeah, in our view, lawyers have an obligation to take whatever steps they're capable of to ensure that the data that they're storing is encrypted. Encryption still works. It's an important thing for people to understand, even after all of these disclosures. If you use the right encryption, it's virtually unbreakable. Now, that doesn't mean that your encrypted communications can't be intercepted. If I send you an encrypted email, you need to decrypt it in order to read it. And so someone who has hacked into your computer, into your endpoint, will be able to read the email. But if you're storing encrypted information and you've done it properly, it is really quite safe, and even an intruder who could get in there could use all the computing power in the world and would not be able to decrypt it. And this isn't hard to do. If lawyers don't have the resources to do it themselves, then I think bar associations need to be making that available to lawyers. Well, absolutely. Here again, I think Europe is ahead of the United States. In the U.S., the NSA has been collecting and storing all of this telephone metadata itself for up to 5 years. And one of the potential compromises that's being discussed would be something that looks like the European Data Directive that was just struck down by the court, which is to push the information out of the NSA and have the companies themselves hold it for that period of time. That's obviously insufficient as far as we're concerned. Although I should say a small step in the right direction. It's less dangerous to liberty if the data is spread out among private companies and the NSA or the FBI need to go to a court to get permission to get it, rather than having it themselves at their disposal so they can run whatever analysis they want to on a daily basis. But no, our view is that these data retention programs essentially arose because of capability, not because of debate. For the first time, it became possible, financially and technologically possible, to record and store all of this information with very minimal cost. It used to be extremely expensive to do that. And governments around the world and corporations did it because they could. And now we're having this debate. You're having it in Europe, we're having it in the United States. What are the trade-offs? Certainly there are benefits to law enforcement from having retained data, but that's only part of the discussion, not all of it. The U.S. Constitution was written to make the job of law enforcement more difficult, not easier, to put some protections between the state and individuals. So, and I also think that there's a lot more empirical research now that shows that storing information for 5 years is not necessary. That almost all of the requests from law enforcement to it come in the first 6 months, not in the third or fourth or fifth year. And so we need to understand that the benign or benevolent purposes to which this data is being put now could become very dark purposes in a different political environment when it's much harder to turn back. Now is the time for us to be debating the proper balance.